My name is Tony Budidjaja, an arbitrator based in Jakarta. There are several factors that establish Indonesia as an attractive and effective seat for arbitration. To start, the first factor is enforceability. In cases where the opposing party's business headquarters or key assets targeted is located in Indonesia, or the governing law of the contract points to Indonesia, it is worth having Indonesia as the seat for arbitration. In my experience, enforcing Indonesian national award is more efficient and convenient than enforcing international awards. Under the prevailing Indonesian arbitration law, number 30, year 1999, if the seat is in Indonesia, the arbitral awards will be legally treated as an Indonesian national awards. Further, the national arbitral award is readily enforceable upon registration in the relevant court. Contrary to international arbitral awards, there is a strict deadline for filing an application for setting aside of national arbitral awards in Indonesia. The deadline for such is 30 days from the date the award is registered in the court. Furthermore, the Indonesian statutory grounds for setting aside and refusal of enforcement of the national awards are more certain and restrictive than those for international awards. Second, although Indonesia cannot be qualified as a model law country, the party autonomy is greatly appreciated and respected. In Indonesia, foreign arbitral institutions are allowed to administer international arbitration cases seated in Indonesia. The parties also have the freedom to apply foreign law and use a foreign counsel or arbitrator for their arbitration cases. If wanted by the parties, the arbitral tribunal has the power to use English or other national languages in the arbitration proceedings. Third, there has been a shift in the attitude and views of Indonesian court toward arbitration following the change of businesses' preference in the methods for settling their disputes. Despite the inevitability of litigation, circumstances stemming from the COVID-19 have influenced a change of attitude toward litigation in recent times. The appetite for litigation has gone down drastically. In recent times, the decisions of Indonesian courts in arbitration-related matters have consistently reflected a pro-arbitration stance. In 2019, Indonesia Supreme Court issued guidelines to judges handling cases of enforcement of arbitral awards in Indonesia, which was applauded as a directive to the judges to strictly comply with the standardized procedural rules of enforcement of arbitral awards and make more serious efforts to create Indonesia's image as an arbitration-friendly jurisdiction. The third factor is the availability of low-cost infrastructure for arbitration. Experience has shown that by being held in Indonesia, parties are able to create significant efficiencies for the administration of arbitration. In recent times, arbitration hearing venues and facilities are flourishing. I can say that the overall infrastructure for arbitration has grown tremendously in recent years due to growing demand for arbitration and surging awareness by the general public on the importance of arbitration. Today, Indonesia has so many professional transcribers and other arbitration support professionals needed for an effective arbitration hearing. Fifth, third-party funding is legally permitted. Indonesia does not have any regulatory framework on third-party funding for litigation or arbitration proceeding, so it is in principle permitted. There are no disclosure obligation or restriction on how parties finance their litigation or arbitration proceedings. There are also no regulation that prohibit a third party from paying the cost of another party's case. So the appointed judges or arbitrators are typically not in the position to question the source of the party's funds. Last but not least, a notable factor that makes Indonesia an effective seat for arbitration is leisure tourism. Having the arbitration seated in Indonesia would allow the disputing parties and their counsels to enjoy the natural beauty of Indonesia, such as the island of Bali, which is a leading global travel destination. There are so many pleasant and low-priced places to arbitrate in Indonesia. This also complements the cultural diversity advantage of the Indonesian society in catering to the needs of the international parties by offering a friendly and peaceful environment. There is no single international qualification standard for an arbitrator. As an arbitrator, I am expected to understand law, the practice, and the business. With the saying that an arbitration is only as good as the arbitrator, the challenge for me is to have and maintain a high standard of professional qualification in international arbitration to match and support my vast practical experiences and legal expertise. Other than competence, I believe it is vital for an arbitrator to work with the highest level of integrity. Arbitrators that have integrity stand above those that don't. Parties may choose an arbitrator over the others due to his adherence to arbitrators' ethics and familiarity with the international arbitration standards. I noticed an increase in demand for an ad hoc arbitration amidst the pandemic that faced business owners with uncertainties. This trend seemed to lean toward a preference provided by ad hoc arbitration, which gives disputing parties more control and flexibility of the arbitration process. Indonesian law enables the parties to choose between ad hoc and international or institutional arbitration. The financial difficulties of disputing parties have made ad hoc arbitration a more cost-effective option suitable for all types of claims and widely popular. Although I personally encourage the growth of both types of arbitration, ad hoc and institutional arbitration, I view this as a good option for any arbitration seated in Indonesia. The current COVID-19 pandemic has added a fresh challenge in conducting arbitration. In many instances, a party to an arbitration or the arbitrator is not comfortable with physical hearings, and arbitral proceedings could suffer indefinite delays due to the pandemic. Justice delayed is justice denied. Delaying the arbitration is defeating the purpose of the arbitration. There are always parties that would indulge in dilatory tactics, but the arbitral tribunals are vested with the power to adopt virtual hearings through appropriate procedure. As long as principles of natural justice are not violated, the tribunals can direct for arbitral proceedings to be conducted virtually. In such circumstances, an arbitrator could offer or electronic arbitration services that include remote witness and video conferencing services. I believe virtual hearings in arbitration are an effective tool for cutting costs and saving time. The same must therefore be encouraged as far as practically possible, provided the interconnectivity is uninterrupted and streamlined. Unnecessary adjournment may be avoided in virtual hearing, as specific time slots are fixed. Ultimately, the ability to navigate arbitration hearings in the wake of the COVID-19 outbreak is very important. A strong and agile arbitrator must have the skills and commitment to make virtual hearings faster, cheaper, and better than the traditional arbitration mechanism. Thank you for listening, and I hope this information is informative to you.